Welcome to Legal English, class number 9. Today we'll have a very brief overview. This is going to be a short class about administrative law in the United States. United States administrative law basically deals with governmental oversight and usually we refer to it government's role in regulating the economy, because America has very few state-owned companies. You have Amtrak and the USPS, but usually when the federal government steps in, and it's not related to something like law enforcement, it's mostly through regulatory agencies. You have the Administrative Procedure Act, which applies to state governments and the federal government, and it lays out some mechanisms to controlling this governmental oversight. So an agency is going to be a body of the government that usually has the power to regulate things. So there's a number of agencies. Some of the most important ones, you have the EPA, which is the Environmental Protection Agency. That is a cabinet level position. So a cabinet is the main advisors to the United States president. The EPA is considered a cabinet level position. But usually it's departments that are considered cabinet level positions. So departments would sort of be similar in scope and size to the idea of a ministry in other countries. So you have the Department of Labor, of Education, of the Department of Defense, which is one of the largest ones. But like I said, the United States government doesn't really provide, the federal government doesn't provide, too much in terms of education, which is why the Department of Education really has a reduced role. It doesn't provide a lot of healthcare. Most of the healthcare it provides is through the Veterans Healthcare Administration, and that is governed by the Veteran Affairs Department. So the Department of Veteran Affairs. So Army veterans and armed forces veterans in the United States are entitled to free healthcare, but most regular people are not. Older people have Medicare, which is the government incentive and a help, which is like a money help for insurance for older retired Americans, and all those things are sort of governed by the Administrative Procedure Act and administrative law in general. Still, it's a reduced role. It's not the same as we see here. So really, when we're talking about the administrative law in the United States, we're more concerned with rules and regulations because that's mostly what the federal government does. So the Chevron deference is a doctrine which was instituted in a Supreme Court case. It basically says if a government agency has an understanding, then that is to be presumed to be valid until proven otherwise. So if the government agency has an understanding about something, we're going to defer to that. Because Chevron is an oil company, and they were questioning some EPA regulations. Basically, the record and the exhaustion of administrative remedies. So you can only you can only sue really the government in court, in a federal court, if you're suing the federal government, after you've gone through all the administrative remedies that you could possibly use. Arbitrary and capricious is a standard that is used by courts for informal rulings, usually, to basically say, well, this is an arbitrary and capricious rule act by government and it's not valid. There was talk about doing that with a rule that was issued a few years ago about, every time you want to institute a new regulation, you have to repeal 2 existing pieces of regulation. And some people were saying, well, that's clearly arbitrary and capricious. How are we supposed to do that? It's hard to translate these terms because it's really more of an American idea, but it's just showing you that they have separate standards of review for the public administration. So here, arbitrary and capricious is the legal standards courts use to review agency decisions. We're looking for something that was unreasonable, that is not supported by evidence. So it's different from the reviews we saw in our constitutional law class. Obviously they apply here, but you're not asking to see if something is constitutional. You're just asking to see, is this arbitrary and capricious, or is there legitimate reason for the government to do this? The APA provides some standards for that because they instituted that rule. It's backed from 1946, basically saying that the informal rulemakings had to be made in accordance with a legitimate, a rational reason. It cannot be an abuse of discretion. It cannot be arbitrary and capricious. Substantial evidence. So basically, if the government agency is going to issue a ruling or a rule which is going to be a bit invasive, they have to do so based on strong, substantial evidence. Because a lot of rulings by government agencies interfere with business and commerce, so they have to be backed up by credible and substantial evidence. Deference, if the ruling by the agency is backed up by substantial evidence, the courts will defer to it. So that's called the Chevron doctrine. Plain meaning is usually when a statute or regulation is so clear that there's no rule for interpretation. Because obviously a lot of litigation is based on interpreting what the actual norms by the government agencies mean. Procedural regularity, basically that the rule was created following standard procedure that was not rushed in. So that's another standard of review. Constitutional standards, obviously you cannot have an unconstitutional rule by the public administration. So that's quite obvious. We talked about this on our constitutional law class. Abuse of discretion, so the agencies have discretion to do things, but they cannot abuse it, right? So that is also a standard of review. There's not much to say because these are very open things, and to really understand what it means effectively, you have to read a lot of case law. So really, you're just naming it and citing components of it, but to understand it, how it's applied in practice, you have to read a lot of case law. That applies to basically everything in this course. But the existence, so judicial review would be exclusively looking for constitutionality, right? But that's not all you're doing with the administration. You're looking for other things, you know? The government cannot just create rules for no reason. Americans in particular have this idea of limited government. So if the government is gonna tell people to do something, it has to have a good reason, especially if it's not the legislative body, because Congress can create rules without the same standards of review as the public administration. Because the public administration and the EPA or the Department of Labor, they issue rules that are supposed to be based on evidence, and they sort of do it without going through Congress. Obviously, there's limitations, but because of that, the standards are tougher than Congress or state legislatures. State legislatures can do almost anything. Obviously, the Constitution applies, but the state legislatures can pass a lot of rules if they are approved by the state legislature and signed by the governor. But the federal government and even the state agencies did not have that liberty. So a reflection of that, as I was just saying, is the Chevron doctrine. So it's basically saying if Congress has explicitly left a gap for an agency to fill. So some things, because passing a bill in the United States Congress is difficult. There's a lot of political turmoil, so Congress will allow agencies to regulate, more mundane, everyday things. When they allow Congress to fill those gaps, usually the courts will defer to that judgment unless, it's arbitrary or capricious, it's abuse of discretion, or, it's a violation of any other standard of review. De novo review basically means, the lower court heard the case and they issued a ruling, but that ruling was so tainted, it was so bad, basically. The whole trial has to be remade. And this is important in administrative law because you're dealing with public policy. The appellate court can be, I want the court to do this again because I don't think this complies with, existing regulations and norms. This is not something that applies only to administrative law, like I said, but it's important in administrative law because you're dealing with public policy. So here's a little bit of case law. The Chevron doctrine comes from this case right here, but you have other things as well. Obviously, I always say this, but if you want to work with administrative law from the United States, you have to read a lot more case law on this. This really has been just an introduction. I think it's an interesting subject because you're really dealing more with regulations. It would be interesting to see how those laws also apply to the services the government does provide. Like I said, there's a lot of room for discretion when it comes to the federal government and even more room for discretion in the state government. Please read more case law on this, but this is a good starting point for you to learn the vocabulary. I'll see you in our next lesson, which will be labor law.